actions related to the exploration, what happens in area? In area, should we apply the approach similar to the moon? That like moon belongs to everybody, that moon is common heritage. Should be this approach similar to the exploration of marine genetic resources? Well, if we're going to look to the state positions and if we're going to look to the literature analysis, there are different approaches to this matter. So, I would say that if we're going to accept maritime genetic resources as a common heritage principle, right? Very good approach. It should be compromised between developed and developing states because both of them are having their own interests, of course. And rather than showing their muscles, they should balance their interests and serve to global community. But here, when we talk about like, common heritage of mankind, maybe you guys, distinguished professors, representatives for international organizations having much more greater experience rather than me, have the direct and concrete answer to this matter. What can be calculated as a common heritage of mankind? How are we going to interpret it? What we want to see there? And if we're going to find the common language and accept that, okay, great, amazing, common heritage should be applied, I would rather be skeptical or enter in the discussion with you and ask you to clarify which area should we apply and which law should we apply. Is this high C regime? We all like high C. It's ANCORS 1982 convention and main pillar, like all the principles are there. We cannot go beyond the ANCORS. It's starting point. Even though we don't have any clarification or any exact interpretation what might be genetic resources. We go to other legal instruments such as CBD, such as convention, which is Nicaragua Convention. Also very important to see the BNG Convention, which is still developed. Despite my skeptical approach, it should be developed. We need this convention a lot. So, where are we going there? Which approach should we take? Vice versa? Pro? Against? Where are we going? What would be the final approach? Should we stay on this analysis approach and say, okay, if the maritime genetic resources are exploited from the high C regimes applied. If it's area, then it's area applied. What about comprehensiveness? What about coherence? What about how we're going to regulate all those matters? So we have duplication of the norms. What about the clear legal regulation manner? Is this our goal to make much more complicated story? Or should we compromise or take an action for balancing those areas and balancing the operations related to the exploration issues? Let me finalize here. I give it to you the perspective of ANCORS, and I give it to you perspective of other international related legal instruments. They both find its application. The latest convention are much more complicated, I would say, because they don't really take into account areas beyond national jurisdiction. What I mean, maybe it's a very not clear statement from my side, and let me just simply clarify for you. Those two conventions, Biodiversity Convention and the related protocols, they are just state-oriented, if I could say, in a diplomatic manner. They are underlying the principle of sovereignty. They underline the state interest over the marine genetic resources. Fair enough. But what happens beyond national jurisdiction? ANCORS, very general, not specific norms. Principles clashes. Here there are two other legal instruments, state-oriented. Exploration activities, we have genetic resources on the hand. How are we going to regulate it? So maybe this is the one approach from the legal perspective, and our international organization can like join here and put some soft law mechanisms in order to avoid any conflict. Okay, there are different organizations which are represented in high seas. So here.
Can you speak to the microphone because translation couldn't be made?
Sorry. When it comes to the international organizations, right, and high sea areas, beyond national jurisdiction areas, here comes a lot of international organizations on the picture. NFOs has been already addressed. The FAO organization also has an interest. There are other also game changers, organizations which want to be involved. Heritage issues. What about organizations which are working on protection of heritage matters? They also have their application and employment there. So my question there is that, okay, law is complicated, international organizations approach is very wide, very complex, there are a lot of organizations, and we have one general, it's International Seabed Authority, which tries to be there to protect marine environment, but also to push step ahead and maintain sustainable development. And still, it's rather than very old case we are here presenting matters, bless you, presenting matters such as sustainable development on the one hand, and another hand is protection of marine environment. And the main goal here, and those principles are applied when we are talking about exploration of marine genetic resources. So let me quickly move to the point of international organization, because we have to think about exploration and getting genetic resources as one of the important matters. But what happens about over-exploration issues? What happens if I get some marine genetic resources and I want to commercialize it? Why not? But if we are going to commercialize it, the matters of intellectual property, IP law finds an application, direct application. Hello, darling. It's very, very, very difficult matter. Why? Because imagine we have marine genetic resources. Okay. Is this commercialized yet? No, we are not knowing it yet. Trade law applies? Yes, of course. Property law, intellectual property law applies? Yes, of course. Copyright law applies? Maybe. But if the law applies, we have to have licenses, we have to have commercialized norms, we have to have liability matters, we have to have protectional matters, we have to have insurance matters. Trade secret, marine genetic resources might be interpreted as a trade secret. We like the concept, but we are not sure if it will be, because at the moment the legal regulation norms are not there. Let me also say one few words there, because when it comes to intellectual property rights and IP protection, it's obvious that we need it because there is a privacy, by-privacy matter. Even though the ANCORS does not really have the by-privacy provisions and regulations, we still need to take this information into account, because academy and scholars and related organizations are talking that those matters would be problematic because it comes to the over-exploration and we want to protect marine environment. So this is the intellectual property rights. So let me quickly now put all places and all elements in nutshell. Sorry. Just a few minutes. Thank you. To put all elements in a nutshell way, UNCLOS, very good convention, Constitution of the Sea, doesn't really directly tell us what could be calculated as genetic resources. We go to clarify it with other instruments, but the clarification is not as big problem as the applicable law. So then we move to the international organizations, which has different approaches, and we have to compromise and help them to coordinate. And we have to also think about benefit sharing process. Here, developing states should be compromising with each other and balancing the common interests and balancing their interests. And there's a final point, maybe the conference in Glasgow, which has been approached by different developing states, is very good to remind us, because we are here to put our milestones and our play and role to protect marine environment, because it's our future and it doesn't belong to us, it belongs to the generation to come ahead. Thank you so much for your time. If you have any questions, I'm more than open for that. Thank you again.
Thank you very much for, first of all, respecting the time. More senior scholars to learn from younger also about that. Let me joke. And the first thing myself, of course. But before to pass, to give the floor to our next presenter, I would just underline a few points, if I can abuse of my role of moderator. And what is attractive to me, and also yesterday sometimes, is a topic that we have heard, the reference to the relationships between orders, applicable law. One of our colleagues talked about fragmentation of international law and so on. But after all, the point is maybe to try to change the approach to the study of law and try to see that as global law, where different norms concord to regulate the same fact and the same area and the same regime. So it's a sort of integrated approach to law, and especially to international legal order regulation, I guess. But I would be very happy to have more discussion about that and about the common heritage of mankind, of course. Because after all, it's always a matter of consideration of what is a common heritage. It depends which kind of heritage you want: economic, cultural, traditional, and so on. So we will have further discussion after. So next on my left side, I have the privilege to introduce you one more young scholar from Karadağ. It is my privilege to introduce to you Ms. Seyhan Gul-Tilmaz, who is a PhD candidate at Karadağ at Ankara University. She's a degree in Sea and Maritime Law, and she's also a member of a few and on a variety of field of law of the sea projects, like a project on Turkey's sovereign rights of offshore energy resources on board the sea, clean Mediterranean Sea, and so on. And she works also as an advisor on behalf of the Ankara University National Center for the Sea and Maritime Law. But also let me just to invite all of you to celebrate the support in organizing that conference today jointly with Berisa. Also to do that great report and contribute to it. So she's going to present her research on utilization utilization of the marine renewable energy resources on the IAC. Please, you have the floor.
Thank you so much, Madam President, for your kind words. It's a great pleasure for me to be here as a speaker today. I would like to thank the UK and my team for this privilege. Today I will explain the utilization of the marine renewable energy resources on the high seas. Within the scope of my presentation, first I will evaluate the legal status of marine renewable energy resources under the regime of the ANCORS. Then after evaluating the legal regime of these resources, I will evaluate the legal status of marine renewable energy units. And after evaluating the legal status of these units and resources, I will briefly explain the current regime for the high seas under international law, and I will evaluate which freedoms can be applied for the marine renewable energy utilization of the high seas. After evaluating the legal status of the high seas regime, I will lastly evaluate the current challenges under the current regime for the high seas, for the marine renewable energy utilization, and in the last part of my presentation, I will suggest some potential solution and alternative regimes for the utilization of marine renewable energy beyond the national jurisdiction. So first of all, what is the marine renewable energy resources? Actually, there is two kinds of marine renewable energy resources. First, the energy that directly generates energy from the features of the sea and another elements of the sea, which is called as ocean energy. And secondly, we have energy only used the sea space for energy utilization, which is the offshore wind energy and offshore solar energy. Right now, offshore wind energy is the most developed and mature energy in the world. Most of the developed countries are developing offshore wind turbines, offshore wind farms within their national jurisdiction to reach daily zero emission goal. So what is the legal status of these marine renewable energy resources? As we all know, ANCORS mostly regulate all maritime activities within its scope. However, there is no direct reference to marine renewable energy utilization within the ANCORS. However, when we look at the provisions of the ANCORS, natural resources occur differently for each different maritime zones. For example, under the EEZ regime, ANCORS regulates production energy from wind, water, and current, which are the marine renewable energy resources. In this sense, there is no obstacle to classify marine renewable energy resources within the regime of the ANCORS, within the regime of international law of the sea. However, when we look at the resources of the high seas, we can clearly see that there is two resources regulated under the regime of the high seas, beyond national jurisdiction actually, which are the fisheries and the minerals. But ANCORS regulates these resources completely differently, like two sides of one coin, which for the fisheries, ANCORS regulates freedom of the high seas. For the minerals, there is a comprehensive regime which is regulated by the International Seabed Authority. But I think that both of these regimes is not feasible to utilize marine renewable energy beyond the national jurisdiction. So in the near future, I think that a hybrid approach will be needed. So for the utilization of these kind of resources, we need some marine renewable energy units, deployment of them. So what is the legal status of these marine renewable energy units? As we all know, classification of the offshore facilities has been a controversial issue in the law of the sea for a long time, especially for the mobile units. Generally, the classification of this kind of offshore facilities can be changed within the concept of the different international conventions. For example, as a normal fixed platform considered as an installation, artificial islands. However, in some IMO regulation, they considered as a ship for the liability purposes. However, in the case of marine renewable energy units, we can classify them as either ship or either artificial islands. However, when we look at the main objective of this installation, these units, we can clearly state that the main objective of this unit is the production of energy, not navigation. Therefore, even though mobile marine renewable energy has a capability of move or seagoing ability, there is no feasible way to classify them as a ship. In this regard, for the safety issues related to safety, I will evaluate them as an installation under the regime of ANCORS within the presentation. So after evaluating the legal status of the units and resources, I will briefly explain the IC regime. As we all know, IC is regulated as a customary international law, and these areas are open all states, either landlocked or coastal like part to UNCLOS are not. And in this case, all states have equal and undivided right to use high seas. Also, UNCLOS state that high seas cannot be controlled, and no state can claim any sovereign right on the high seas, which can hamper the utilization of the marine renewable energy beyond national jurisdiction. Even though UNCLOS regulates enumerated freedoms, these freedoms are not absolute. There are some restrictions regulated under the UNCLOS and under the international law. UNCLOS states that these states must exercise it peacefully with due regard for the interests of other states and with due regard to rights with respect to the seabed mining. So the restriction for the freedom on the high seas is like defined with the due regard principle, which is not defined under the UNCLOS regime. So it is possible to say that with the current regime we can develop, manage, or operate marine renewable energy units beyond the national jurisdiction under the freedom to construct artificial island installation and structure. However, since UNCLOS does not give direct reference to their utilization, I think that there is a gaping hole which affects other states' freedom and activities related to deep seabed mining. So, I explained the legal status of the resources and the legal status of the high seas related to marine renewable energy utilization. And in the last part of my presentation, I would like to briefly explain the UNCLOS silence and current challenges for the utilization of marine renewable energy on the high seas. First, like I tried to explain, there is only due regard principle regulates the freedoms and restricts the freedoms, and I think which is not adequate to regulate this kind of energy utilization on the high seas, and it can create conflicts between the other states' freedoms and between the deep seabed mining activities in the area. Also, in the case where there is an extended continental shelf, also there might be a conflict between the activities of the coastal state and between the activities on the high seas. So, the regard principle actually does not create a priority, none of these activities, which is creating challenges to develop this kind of units beyond the high seas. Also, like I explained earlier, no state can claim any sovereignty on the high seas, which is the counterpart of equality and freedom on the high seas, which since high seas regulate as a common space under the international law of the sea. However, especially offshore wind farms located in a vast areas, and they covered so many space in the sea. Therefore, they will eventually create a permanent character on the sea space, and it will be caused de facto appropriation eventually, which can affect the common status of the high seas. So right now, the current regime for the high seas serve as a first-served basis, which is not equitable way to regulate this kind of activities on the high seas. So, since high seas are open all states, there is no coastal state jurisdiction on the high seas. So, flex state jurisdiction is the exclusive jurisdiction on the high seas, which can be insufficient for regulating this kind of activities beyond the national jurisdiction. Also, like we all know, in the shipping industry, as a safety link, port state control has created, but in this case, beyond the national jurisdiction, also it is not a available option for to create such a safety link like port state control. Also, another challenge is related to environmental even though marine renewable energy is a zero emission and sustainable energy, we still don't know its effects on the seas clearly. Therefore, even though there are some general rules for regulating the environmental issues under the ANCORS on the high seas, I think that a more specific rules and precautionary approach is necessary. Also, lastly, lastly, there will be some difficulties associated with the commissioning of this kind of disused and abandoned facilities, maybe in 50 years, because ANCORS and the IMO regulation generally focus on the EEZ and continental shelf for the commissioning of the offshore facilities, so there is no direct reference for the high seas also in this matter. So those were the current challenges for the utilization of marine-enabled energy beyond the national jurisdiction, and in the last part of my presentation, I will briefly explain the potential solution and alternative regime as a suggestion to create it in the near future, hopefully. So the first solution, which is not the most feasible one, is the extending the jurisdiction of coastal states, like the extended continental shelf regime, which will harm eventually the equity and common status of the high seas. Also, it is not feasible. It will harm the rights of the landlocked states and the states located in disputed areas. Also, another way to regulate this kind of activities maybe can be establishment of the regional management. However, it will also hamper the equity, and it will not avoid the free entry and free riders system which happens in the fishery beyond national jurisdiction. Lastly, instead of the regard principle, maybe marine special planning as a management tool system can be created beyond national jurisdiction, for example, of transborder marine special planning. However, for applying marine special planning, there must be a regulatory authority for making the necessary stuff to regulate this kind of special planning. And in this regard, I do believe that a similar regime created for the International Seabed Authority for the minerals can be created for the marine-enabled energy utilization beyond national jurisdiction, since the international management can create the equity and while still protecting the freedom and common status of the high seas. And that was my presentation. Thank you all for your attention.
So thank you very much, Seydan, for being so precise and clear about the current challenges in relation to the utilization of the legal framework in relation to creation, utilization, transport of marine renewable energy resources. And actually, I just want to make a comment about the current situation in relation to the European Union, because you know that in that sense there is a kind of tentative to harmonize the different legal regimes and sometimes to create a unique one for all the European Union member states. Initially with the directive of 2009 modified and substituted in 2018 with the directive 28, establishing a sort of target for EU member states, according to which they are obliged in a certain given time to use in the recent modification, the last modification, at least the 32% of new renewable energies. So that's really interesting because in my idea it can be useful also in terms of try to share the reflection for a common and more possible shared regime, also with third states outside the European Union. So thank you very much for the very interesting contribution, and hopefully we'll have time at the end to have more debate. My next speaker on the list, returning on the right side is Madam Berisha Kokabi. Sorry for my very wrong pronunciation. I promise I will learn more. We are going to return to exploitation from utilization, and this time in relation to mineral resources in the area. But before to give her the floor, let me, as a matter of justice and equity, to introduce her. She is also part of the dream team, women dream team, let me call her in that way, of young scholars of the UCAM, because she's also a PhD candidate at the UCAM, at Ankara University, and she's also LLM, degree in Sea and Maritime Law, and member of few research projects, and also she works as an advisor on behalf of Ankara University National Center for the Sea and Maritime Law. Between many projects she's working, there are few interesting, and one, for example, is in relation to the marine environmental law and national approach to the 22nd meeting of the contracting party for Barcelona Convention. I missed the part here. Which contracting party? There are a lot. So thank you very much. The floor is yours.
Thank you. Dear ladies and gentlemen, before to start, I would like to express my gratitude for being here, and I would like to extend my best regards to the team of the UCAM and Turkish Law Platform for giving this opportunity to me. Now, today I'm going to talk about the exploitation of mineral resources in the area, and under the United Nations Convention on the Law of the Sea, and under the auspices of the United Nations International Seabed Authority, I would like to try to answer following questions in my presentation, starting from the need for deep seabed mineral. What is the deep seabed, and what is the reason of the establishment of the area, and what is the role of the International Seabed Authority? What is the concept for the resource in the area? Then I will move on to the process from the exploration to exploitation phase by explaining the current challenges. We all know that we are all the consumers of technologies like smartphones, electric cars, or even computers. So we need minerals to be exploited, provided for us to move on. But right now, mineral resources on shore is depleting and struggling to meet this demand. And humanity is looking for an alternative resources to exploit. Now, after the discovery of deep seabed minerals, which means like 150 years ago, now some companies and states are ready to exploit those minerals thanks to the technological advancements. And those exploitation activities might bring the prosperity of the world or might bring the end of the world. We still don't know the current answer. Now we talk about the deep seabed minerals. We need to understand what is the deep seabed. To be short, deep seabed mainly starts where the continental shelf ends. And deep ocean mostly covers the 50% of the Earth's surface. And deep ocean is a wide area of mineral resources. And deep ocean mostly falls in the scope of the area, which means the areas beyond national jurisdiction, seabed area. Mostly beyond the nation state's jurisdiction, continental shelf. And the area is considered common heritage of mankind, which means it belongs to all humanity. But what was the reason behind the establishment of a new maritime zone as the area under the UNCLOS? The reason was with the effect of the new international economic order, which is aimed to bring equity in the world's economy and aim to share riches of the sea among the states. With the effect of this understanding and Arvid Pardo's famous speech, as Professor Hamburg mentioned yesterday, the area is accepted as the common heritage of mankind, and that principle formed the 11th part of the UNCLOS. With the compromises between developing and developed states, that principle was a little bit amended by the implementation agreement. And as the area, the resources of the area is also considered as a common heritage of mankind. And there are some rules derived from this principle, such as non-appropriation, exclusive use for peaceful purposes, protection of marine environment and human life, effective participation of developing states, which is very important, equitable sharing of financial and economic benefits derived from the activities in the area, carrying out activities in the area for the benefit of mankind as a whole. So, when we need to look at the role of the International Seabed Authority regarding the exploitation activities in the area, the ISA mainly has three roles regarding those activities. As a lawmaker, ISA is mandated to adopt and uniformly apply rules, regulations, and procedures. As a regulator, ISA is mandated to process, consider, approve, or reject applications for the plan of works for the exploration and exploitation activities. As a supervisor with its enforcement powers, ISA is obliged to ensure compliance with its framework. ISA works through its organs, starting from the General Assembly, which is the supreme organ of the ISA, Legal and Technical Committee, and the Council, and the Enterprise. Enterprise is aimed to conduct exploitation activities for the benefit of humankind as a whole, but it's not in the operation yet. Right now, today, while we are sitting here, the ISA Council is debating this issue, and in the future might be the one, the enterprise might be the one who is conducting exploitation activities in the area. And moving to the next question, what is happening about the transition from exploration to exploitation? Exploration means extensive pre-production survey for the deep sea bed minerals. Where are they located? What are their economic value? And what will be the effect of the marine environment? For an entity, presence of a sponsoring state is required with an approved plan of work for the whole exploration operation, which contains some related documents, and also the exploration contract, which will be conducted by the contractor, and the ISA is needed. The maximum period of this contract will be 15 years, but renewable is possible. Right now, there are 21 contractors are in place from different nations, but however, only 1% of area is explored. Moving to the exploitation generally means the recovery for commercial purposes of resources in the area with the exclusive rights. Again, for an entity, presence of sponsoring state is needed, and with the approved plan of work and exploitation contract. Different from the exploration, these contracts can be conducted up to 30 years. When we talk about the exploitation, I would like to draw a general legal framework for these activities. As I mentioned, the UNCLOS, especially Part 11, Annexes 3 and 4, Implementation Agreement, and the ISA's Mining Code, which contains rules and regulations related to exploitation and exploration activities. Right now, draft exploitation regulations are debating in the ISA. For commencing exploitation activities in the area, their adoption is waiting. And also other rules of international law that are not incompatible with the UNCLOS will be the current legal framework for the activities in the area. When we look at the qualified actors of the conducting activities in the area, we could say that state parties to the UNCLOS, their enterprise and their national or judicial person having the nationality of the state party and sponsored by a state party. What is the procedure relating to exploitation activities in the area? As I said earlier, we need a plan of work which contains certificate of sponsorship, mining work plan, financing plan, environmental impact statement, and closure plan. All operations should be foreseen beforehand, and the application of plan of work will be submitted to legal and technical committee. After the consideration of LTC, it will be approved or rejected by the council. When we look at the draft exploitation regulations, we see that that regulation has not defined the exploitation contracts. We could define the contract as an agreement between the contractor and the ISA with an exclusive right to the contractor to conduct exploitation activities in the defined area and mineral resources in accordance with the international law in return for the contractor's obligation to pay royalties. That contract has a number of legal natures, starting from internationalized functional contract, commercial contracts, and administrative contract. And when we look at the picture, we talk about the triangle relationship with the sponsoring state, international seabed authority, and the contractor. They have several obligations regarding to exploitation contract, and they will be liable for their wrongful acts. So, I would like to move on to current challenges before the exploitation phase, which is the effective control of sponsoring state, distribution of benefits, environmental challenges, and lastly, position of non-party states. As I mentioned earlier, an entity must be sponsored by a sponsoring state, which has effective control on it. And the reason behind that, ANCORS didn't want any situation like sponsorship of convenience. They want the situation that someone will be liable and a liable regime. In this sense, ISA, until this time, ISA interpreted the effective control as a regulatory control, which means if a company if an entity establishes a company as in sponsoring state's jurisdiction according to its national law, it will be considered as a regulatory control, meaning that state has effective control over that entity. But it's not going to be all the same when you take into consideration economic control of the company. Right now, some developed states companies established several companies in Pacific Island countries, and they are enjoying the privileges of the developing states, which is conducting activities in the reserved area, which is not something that UNCLOS desires. In order to prevent that situation, clear definition of effective control with integration of economic and corporate control factors are needed. For the distribution of benefits, currently ISA hasn't decided what will be the payment regime and how to distribute the benefits among states. Before the commencing exploitation activities in the area, this issue should be decided because it's one of the most important points of the exploitation activities in the area. When we look at the environmental challenges, I like this photo because always they say we need mineral resources for the transition. Really, for the what at cost. When we look at this, it's really funny. And right now, our knowledge about the space is more than our knowledge about the deep sea bed. We need more scientific research to understand what will be the harm of the marine environment. And also, in case of the liability gap, what will be, who will be the liable, who will be paid for the recovery of marine environment. ISA is deciding to establish an environmental compensation fund for this. But however, there are so many things at stake right now, and some countries, especially Costa Rica, has stated that deep seabed mining activities shouldn't start unless we are sure about the damage of the marine environment. Including some European Union states, they said they're not going to be sponsor activities in the area unless the system is ready. For the position of non-parties, we talked about the common heritage of mankind. But who is the mankind? Or just the parties to the UNCLOS, or the whole future generations, or all states, whether they're party to UNCLOS or not?
We understand that mankind covers all the nations, whether they are part of the UNCLOS. But however, non-state parties to the UNCLOS cannot join the activities in the area. They don't have any voting rights in the decision-making process. And when the exploitation activity starts, with the gap between developing state and developed state will increase. And when we look at the war among non-state parties to the UNCLOS, we see most of them are developing states. So, aim of the legal regime of the area was the supporting developing states, but they are not part of the system. In case of Turkey, Turkey is not part of the UNCLOS because of its national interest, but Turkey is not or didn't object the regime of the area. Oppositely, they favored of the regime of the area. In case of the unwanted consequences, there must be a solution. ISA shouldn't leave behind those countries. ISA should let them in. There must be a supplementary agreement for this, such as fish stock agreement allows non-state parties to become a part of the contract, or ongoing draft BBNJ agreement states that you can party to the UNCLOS, even though you're not party to the UNCLOS, you can be party to the BBNJ agreement. We understand that there must be a solution for this, otherwise those countries will be left behind. Thank you. In order to conclude my presentation, we can say that need for deep seabed minerals in the area is emerging day by day, as to be satisfied, in line with the international law, including the ISA's regulation, by taking environmental and human life concerns into account, with the belief of common heritage of mankind, whether the mankind are part of the UNCLOS, providing all entrepreneurs fair competition standards, whether they are part of the UNCLOS. And this, I am concluding my presentation here. Thank you for attention.
Thank you very much for that very great presentation, and also to respect the timeline. So very few points of interest to me, and I hope also for our colleagues. But the returning point is always the same, so to be centered on that aspect in relation perhaps of my area of work is the human factor. The human factor and jointly the environmental one, because they are a unique one, especially when we talk about marine environment, marine resources, the uses of marine resources for renewable energy and so on. And in fact, what is interesting is that the human rights jurisdiction, both at the regional level and at the universal level, especially the UN Human Rights Family, I know that there are many countries that are not party to the Covenant on Civil and Political Rights, including the United States, I guess. But very recently sanctioned Australia because, without entering into the substance of the case, because of the omission of the state in preserve the environment, the ecosystem, including the marine ecosystem, and save the indigenous people living in that region. So it is quite interesting to me that we must, when we talk about mankind, we must have human beings at the center. So thank you very much. And last but not least, returning to my left side, with a very great pleasure introducing you, Madam Dr. Ekaterina Anisigina, is a postdoctoral fellow at the University of Hamburg in Germany, and she holds a PhD in law from Queen University in Canada. Her main research was devoted to the limitation of extended continental shelves in the Central Arctic Ocean, so we're going to the north area, and during her PhD also conducted a visiting research period at Maritime Institute of Luxembourg for Procedural Law, Scandinavian Institute of Maritime Law, and International Institute for Applied Systems Analysis, between others. So she is going to present her research on challenges in the protection of the sedentary species of continental shelf beyond 200 nautical miles. Please, you have the floor. Thank you.
Thank you so much. So, first of all, thanks a lot to the organizers for having me, and that's a pleasure to present today on the challenges in the protection of sedentary species on continental shelves beyond 200 nautical miles or extended continental shelves. So, sedentary species are regulated under the regime of the continental shelf, and pearl oysters, crabs, lobsters, corals, sponges can be considered as sedentary. And it is important to protect sedentary species because they are part of ecosystem, they represent biodiversity, and they also create structural habitat for other species, including commercially viable fisheries. And there is a possible gap in the protection of sedentary species because Article 77 of ANCORS, that is addressing the scope of rights over the continental shelf, does not mention any conservation or protection rights. It only mentions exclusive rights of the coastal state to explore and exploit resources. And, well, if we compare to similar provisions of Article 56 on the scope of rights over the exclusive economic zone, we will see that coastal states here have rights to conserve and manage alongside with exploitation. So there might be a problem. Protection of sedentary species is maybe not a huge problem within 200 nautical miles because even though sedentary species are excluded from the regime of the exclusive economic zone under Article 68, coastal states still can protect those species under Part 4 of Article 61 as species associated with or dependent upon fisheries. But the problem arises beyond 100 nautical miles on extended continental shelf, of course, if a coastal state has a continental shelf, because here we have a possibility of conflict of rights of coastal states to protect and conserve sedentary species and freedoms of the high seas. So, if a coastal state unilaterally imposes some conservation or protection measures, that might be considered as an infringement on freedoms of the high seas and as unjustifiable interference with those freedoms. And what can threaten sedentary species on the high seas, for example, bottom trawling. Bottom trawling is by default a legal fishing method that involves dragging nets with heavy weights across the seabed, and though it does not target sedentary species, it damages them. Here you see the result of bottom trawling. All the corals and sponges were destroyed. So, well, can coastal state do something about that? And there might be other conflicts as well. So, infringement of fishing would be prohibition of bottom trawling, for example. But marine scientific research also uses bottom trawling. Right to lay submarine cables and pipelines also can interfere with rights of the coastal states, especially in light of recent explosions on, let's say, Russian pipelines. So that definitely damages sedentary species within exclusive economic zones of other states. Can a coastal state impose some additional regulations, and how far can it go? Coastal states can also have problems with regional fisheries management organizations. And that question already was raised by Norway and Russia at the Northeast Atlantic Fisheries Commission. Can a coastal state unilaterally protect sedentary species in the convention area of an FMO? Well, coastal states definitely would argue that yes, and other members of an FMO probably would suggest that only FMO has the right to regulate fisheries in the convention area. So, if we're going back to the interpretation of Article 77, there are different means to support position of a coastal state. First of all, coastal state can argue that the right to consult and protect is implied, and Article 77 should be interpreted broadly because rights of a coastal state over the continental shelf are exclusive as compared to rights in the EZ that are not exclusive, right? So if a coastal state is not exploiting its sedentary species, that might involve conservation as well. Also provisions of Part 12 would support that position because coastal state has not only rights but obligations to protect marine environment within its national jurisdiction. The object and purpose of ANCORS also supports coastal state position because definitely protection of marine environment was one of the objects of the ANCORS. And the last one is state practice can be used as supplementary means of interpretation of Article 77, and there is some state practice now that would support position of the coastal state. For example, this is a map of Canadian waters, and within 200 nautical miles, Canada establishes some refuges where bottom trawling is prohibited, and some of those refuges are specifically tailored to protect corals and sponges. Question is, do they consider that they use continental shelf rights to establish those refuges, or they're using rights under the regime of the exclusive economic zone? And it's not clear because Canada establishes those refuges under the Oceans Act that regulates both continental shelf and exclusive economic zone. Evolutionary interpretation of Article 77 is also possible. So even if at the time of adoption of the ANCORS, states did not care about protection of sedentary species, now with the proliferation of environmental instruments, it is possible that the protection of sedentary species should be included in the package of coastal state rights over continental shelves. And the last one is to establish the existence of customary law, but that is more complicated because huge studies should be conducted in this regard. The interpretation of Article 77 is not the only problem with the protection of sedentary species. Let's say coastal states do have a right to protect, then they should balance those rights with freedoms of the high seas. And the problem is that applications coastal states owe to other stakeholders on the high seas are not equal to the obligations that actors on the high seas owe to the coastal state. So under Part 2 of Article 78, coastal states have an obligation not to infringe or unjustifiably interfere with the freedoms of the high seas. But actors on the high seas have an obligation of due regard. Well, the Chavez arbitration case addressed that problem in connection with a different matter and considered that those obligations are functionally equivalent. So both actors would have due regard towards each other, which simplifies the issue. And then before imposing some conservation or protection measures, coastal state would have to run a balancing test. And Chavez arbitration also suggested what should be considered in this balancing test: the evaluation of the extent of the interference, availability of alternatives, and importance of the rights and policies at issue. And here, just an example of a balancing test of coastal state rights and flag state rights in case the coastal state prohibits bottom trawling on extended continental shelf. So the extent of interference would be important. Is it a prohibition of all human activities or just a targeted prohibition of bottom trawling? Then because prohibition of all human activities might be too invasive and would be a violation of Article 78. Then a coastal state would have to consider fishing practices in the area. For example, if bottom trawling already happened in this area, there are no sedentary species to protect, yeah? So that should be a matter to address. Availability of alternatives. Are there any methods of fishing that are not damaging as bottom trawling, for example? And the presence of endangered species. So can coastal state impose stricter measures if there are some rare clusters of corals on its extended continental shelf. And environmental obligations of flag states probably will play in favor of the coastal states as well. Because it's not only a coastal state that has environmental rights and obligations, but also actors on the high seas. And in the South China Sea arbitration, the tribunal concluded that flag state is under the obligation to ensure that its fishing vessels are not involved in the activities that undermine the flag state's obligations under the ANCORS. So most likely, bottom trawling is actually in violation of flag state's obligations. That is just an example of the balancing test that can be run for pipelines and so on. And the last challenge is protection of sedentary species on the overlapping extended continental shelf entitlements. Here, two coastal states would have conflicting rights. And let's say if one state wants to impose conservation measures and another state doesn't want so, what will be solution, what will be a result of the balancing test. In Ghana Cote d'Ivoire case, the special chamber concluded that maritime activities of concerned states cannot be considered to violate the sovereign rights of another state if those activities were carried out before the delimitation. But the tribunal addressed activities, not the prohibition of activities. And here it is tricky. Let's say if two students are sharing their apartment, both of them can use the kitchen, but one of them cannot prohibit another to use the kitchen. So it would be the same with two coastal states. One state cannot prohibit another state with equal set of rights not to engage in, let's say, harvesting sedentary species. So here, cooperation between coastal states would be necessary. Question arises, what if we're talking about super rare corals?
Sorry, Katerina, 2 minutes.
Thank you. I'm almost done. So, do the environmental considerations actually prevail over the rights of the coastal state? And here, obviously, our coastal states also have an obligation not to jeopardize or hamper reaching of the final delimitation agreement. So then cooperation is necessary in this case. To conclude, coastal states have a right to protect, preserve, and conserve sedentary species, but these rights are not absolute and must be balanced with freedoms of the high seas and rights of other stakeholders on high seas. Environmental considerations could justify the infringement on the freedoms of the high seas, and coastal states must cooperate if the conservation measures are imposed on the extended continental shelves overlapping with shelves of another state. Thank you so much.
Thank you very much, Katerina, for very technical presentation. And but I don't want to abuse again of my role as moderator because we have just 4 minutes, I guess, maybe 4 minutes, 5, to have questions and debate, please. Someone can give the floor. Professor, I see one here, and then Professor there. And see.
Yes, thank you. Just permit me to make 2 comments with respect to the very excellent presentations we've heard this morning. First of all, the expression continental shelf, extended continental shelf has been used. I've used this term myself. It's a term which is frequently used in literature, but it's not quite correct. The arbitral tribunal in Barbados against Trinidad and Tobago has pointed out there is only a single continental shelf, and the International Tribunal for the Law of the Sea in Bangladesh, Myanmar, once again confirmed that Article 76 embodies the concept of a single continental shelf, and Article 83 of the Convention regarding delimitation between states with adjacent or opposite coasts likewise does not make this distinction. So please, there's a continental shelf within 200 nautical miles and a continental shelf beyond 200 nautical miles. My second remark addresses the genetic resources. Let us not believe that we will all become rich by processing genetic resources beyond national jurisdiction. We thought we would become rich by the exploitation of the resources of the deep seabed. We've been waiting for 40 years, and we may have to wait for another 1 or 2 decades. Who knows? Secondly, as far as genetic resources are concerned, it may take between 10 and 15 years to develop a pharmaceutical product from a genetic resource taken from the seas. And lastly, what is the advantage of harvesting genetic resources from areas beyond national jurisdiction if this can be done in areas within national jurisdiction? And I've been told that at least 80% of these genetic resources are also available in areas within national jurisdiction.
Thank you very much. I propose to collect all available questions and then give the floor to our speakers to answer. So please take note of the questions.
Thank you very much. First, let me join in Judge Turkin congratulating you for speakers. Excellent presentations, very clear, very concise. I enjoyed it very much. First question to you, Mariam. I think one of the big problems with the marine genetic resources is that, some states argue in terms of what the law says, and others argue in what the law should say. And that's two different things. And when it comes to the common heritage principle, I think it is important to be very clear on this. And I think it is almost impossible under the Convention to argue that today, common heritage is applicable to marine genetic resources. Perhaps it should. That's an important question. But I think that this kind of division, which has influenced the negotiations between the different groups of states for many, many years now, is actually endangering the entire success of the BBNJ agreement. And so I wonder whether that was a good idea to not exclude it from the negotiations, and I would be interested in your position on that. Secondly, Belarus, if I may, we discussed it briefly yesterday during lunchtime, and I cannot resist. Just a couple of days ago, Germany joined the list of states that have officially declared what is called a precautionary pause concerning any kind of sponsorship of deep seabed mining activities. And I wonder, do you think that is going to have legal consequences, and if yes, in what respect? Thank you.
Thank you very much, Professor. I think that there are another question here, please.
Thank you, Madam Chair. My question is to Dr. Anisiana. Apologize if I mispronounced it. Yeah, misspelling. So, what about the king crab of the sedentary species? Is there any abbreviation about the king crabs or not? And secondly, to Dr. Migaledze, there is a definition in CBD Convention about marine genetic resources, whether you accept or not, or agree or not. And for the Bethensi cases, we have several viable population and species, and we are doing now scanning of these species in my laboratory. Several laboratories do it now in Turkey, and we have some molecules as well. We detecting some molecules for the pharmaceutical industry. Thank you.
Thank you very much. Any more questions? Thank you. I think it is okay. No additional questions, so we can give the floor. 2 minutes each to answer. Please, starting from Mariam.
First of all, thank you so much, Professor Alexander, the judge, and thank you for the question. It's an incredibly good question. First of all, let me briefly, as I have 2 minutes, I have to be precise. Professor, I fully agree with your understanding and with you too. It might be a part of PBNG convention, but as I already told, it's progressing in a developing issue. We don't have at the moment clear answers. So there is a battle, and in this battle we have to somehow compromise, somehow balance approach. So states are themselves, they are pushing their positions. I may understand, but we don't have any results. If we continue like that, acting like that, we will not come up with either clear definition, which the CBD has, either the clear approach under the BBGM agreement. So at the moment, the different actors want to push their positions. So I would gladly, I would be happy if there would be certain and precise regulations of marine genetic resources under the BBNG agreement. But we are not going further, we are standing there. And this is my skepticism about these negotiations, even though I know that next year it would be much more positive with this matter. So on the other hand, definition, which you also mentioned, is very, thank you for this matter because it's also very important because due to the technological development and due to the knowledge that we not know at the moment, it's progressing and we are coming to the discoveries, and it might broaden the approach and definition. And even though ANCORS we have to come up with, we have to go and see ANCORS, but there is not a clear definition in ANCORS even in respect of genetic resources. Exactly. And thank you so much for this approach. And we are seeing much more specific legal instrument, which is CBD, Article 2. But from there, I think, due to the progressing matters and technological innovations, and we scientists and academia, they are collecting data. I think that it would be possible to enlarge the interpretation, and this would need other forums to discuss and other forums to come up with a certain and comprehensive and coherent approach. Thank you so much for your question.
Thank you for your question, Professor. And I'm happy to answer it because we had time to discuss during the lunch break. And some states, including Germany and France, decided to take the precautionary pause until they are sure about the effects of the deep seabed mining. However, right now they are sponsoring exploration activities in the area. Their entities are sponsored by them. So with this pause, what will be the consequences is a very important question. I would like to answer this question in 2 points, points of international law and private law. And when it comes to the ISAs and ANCORS regulation, certificate of sponsorship or sponsorship agreement is regulated through the national laws of sponsoring state. And the ISA regulations and the ANCORS have nothing to do with this internal agreement. And they're only concerned with do you have a sponsorship or not. If you don't, or your sponsorship cut the sport of it, just find another one in a certain time. But in case of the internal, like national position, in the aspects of Germany, German entity is a government entity that conducts exploration activities in the area. In the case of the conflict, I think they will discuss internally, discussing this situation, and maybe since the government entity, they will come up with a solution. But if it's a private entity, company, that is willing to make profit of the exploration and exploitation activities at the end, because they conduct exploration activities with the aim of for the exploitation phase. Of course, there will be conflicts in their national laws according to their investment law, because we're talking about billions of dollars to conduct those activities in the area. And to conclude my answer, I can say that for in light of the international law of the state, there might not be the consequences for the sponsoring state. But according to their national law, of course, there might be some consequences for this pause.
Thank you very much.
Thank you so much. First, I would like to comment about the extent of continual shocks. I agree that
Currently, under jurisprudence, continental shelf is just one continental shelf and there is no inner and outer continental shelves. But I personally believe that there are differences that might influence even delimitation. So, for example, when I was doing delimitation scenarios for the Arctic Ocean, the three-step approach didn't work for extended continental shelves. So we should at least recognize differences between continental shelves within 200 nautical miles and continental shelves beyond 200 nautical miles. But this is true that now tribunals do not recognize it. I hope that it will change in Nicaragua's Colombia case, but we will see. And regarding the king crab, Russia and Norway agreed that king crab belongs to sedentary species, but obviously they are interested coastal states. And if someone doesn't know, the Soviet Union introduced king crab from Kamchatka to the Barents Sea, and then it moved to the Norwegian side. And it's considered as invasive species now because it just doesn't have any predators or competitors. But so far Norwegian fishermen are happy because court is moving up north to the Russian side and they have something to harvest in their waters. Right now there are ongoing disputes between the European Union and Norway on the snow crab, whether snow crab belongs to sedentary species. Canada, for example, considers snow crab as sedentary species, Norway does. So there is some situation of not clear definition what species belong to sedentary, but I mostly address other issues on coastal state jurisdiction and rights to conserve. Thank you so much.
Thank you very much. Thank you for respecting the time, but unfortunately, even if I can say and proud to say that we respected all the time slot, unfortunately we start late, so we are late. So thank you very much for your attention and for being instructed in this panel. And I think that we conclude that session now. Thank you.
Thank you so much for your valuable contribution to us, dear speakers and your attendants, ladies and gentlemen. We will now have a 15-minute coffee break. After we will continue with the second session of the day.